Brian, good to be talking to you.
Thank you, Helen. Pleasure to be here.
ICAD concluded that the problem was not the law, but that the crime of elder abuse was just too nuanced for the law to really capture.
Well, that's not my experience, and certainly it's not the overseas experience. There are two elements of the deficiencies in the law that exist in this country. One is from a civil sense, in other words, disputes between people. There is, for example, out there in law land, lots of presumptions of law, such as the presumption of innocence. There's another one called the presumption of advancement. You may not have heard of that, but the law says if I advance money to you as my daughter, then it's deemed to be a gift. So I've got this problem as a parent now in advancing that money to try and prove otherwise. If in fact you weren't my daughter, just a stranger, and I advanced you $100,000, the law says it's not deemed to be a gift. You are deemed to hold it on trust for me. In other words, it's still my money. So we have, in family situations, this special law which says when parents advance money to children or transfer assets, it's deemed to be a gift.
And is that for taxation sort of purposes? Is that how that developed? Or?
No, it's been as old as Methuselah, that law. And obviously in terms of elder law and elder abuse, it certainly is prehistoric. It's a troglodyte presumption. It should not be there. It should be exactly the same as the other circumstance in terms of advancing money to anybody for that matter. But families somehow are special. But that specialty gives them a particular disadvantage when it comes to trying to disprove that presumption.
And then in the case of the criminal law, the suggestion is, well, sometimes the older person says, no, it's okay, this is a private family matter and I don't wish to press charges against my son, and therefore there's no complaint, the police can't investigate. It doesn't matter how good a law you draft, there's nothing you can do about that situation, so it says.
Well, it's a bit of a fallacy to assume that because a complainant or a victim doesn't want you to do anything as a police officer, that as a police officer you can't. In other words, you can still charge a person despite the attitude of the complainant in many cases. So their consent is not always necessary. It's helpful, but it's not always necessary. For example, with stealing. Now, a lot of elder financial abuse sounds like stealing. The trouble with that is, stealing has three elements. One, that you take something from somebody that doesn't belong to you. Two, you do it without their consent. And three, you have the intention of permanently depriving the person of that. Now, the problem with stealing is, in a lot of financial elder abuse, the perpetrator simply says, oh, no, Mum gave that to me and I said I'd give it back whenever I could. So they don't even satisfy one of the criteria of stealing, of the intent to permanently deprive. So any prosecuting authority has this major obstacle of trying to prove these elements of the offence, where in a family situation, it's really murky in terms of what the arrangement was. In America, they have, for example, an offence called exploitation of the elderly. And it does what laws in Australia don't do. It targets the conduct. It captures the discrete conduct of an abuser. So they're not just a straight stealer, they're an exploiter. So the definition of exploiting is quite subtle. It doesn't pick up the stealing elements. It's subtle in terms of attacking the conduct, specifically of elder abusers, in another context outside the traditional criminal law system. Even in the UK, our motherland, they've introduced what's called a serious crime called controlling and coercive behaviour. So a child can be charged as a serious crime with controlling coercive behaviour. So their conduct becomes now on view as a serious criminal offence if that's their conduct. And as a result, I say those sorts of offences, those discrete offences, act as a disincentive. We don't have enough disincentives for elder abusers at the moment, particularly in the financial area. So having discrete criminal offences increases the disincentive for those perpetrators.
So law reform is a cornerstone requirement, you think?
Yes, but not as the Australian Law Reform Commission recommended, unfortunately, because they said we don't need to tinker with the law when it comes to elder abuse.
They said the laws are
criminal.
adequate.
That's right. I disagree with that totally. Because you even look at the statistics, how many prosecutions are there against adult children for financial abuse of their parents under our conventional criminal laws? I'm not aware of any. Maybe there are, but I'm not aware. So police are not using these conventional criminal laws to prosecute when adult children are obviously doing the wrong thing. They're guilty of bad behaviour, and most people regard it as criminal behaviour because they're taking money from people that doesn't belong to them.
We spoke to a senior police officer who was of the view that discrete laws on the books, called the elder abuse, whatever, crime, would be useful for increasing the awareness of the crime amongst junior police officers. Mm. That if you just put something on the books, even if it replicates the Crimes Act as it exists, it helps improve the situation because people are more willing to act. And so therefore it's an issue in his mind as much of awareness than of the legal instruments to move. How do you know that we don't see these cases in the courts? Simply because we haven't got a lot of community awareness that this is going on, and there's still a pervasive view that this is a private matter and it's very hard to prosecute.
Well, I asked a police officer yesterday from New South Wales who was speaking at this conference, do they keep any statistics or data on the number of charges they bring and the convictions arising out of those charges in relation to financial elder abuse? And the impression I got from his answer was no. So the consequence is we don't have the basic data to determine what is happening so far as criminal prosecution of financial abuse is concerned. We just don't have it. So increasing awareness is great, but it has to come with the ultimate whip, which is prosecution. And having discrete offences is where that comes in. The ability to prosecute attacking the conduct that exists as opposed to the general criminal conduct of most people.
So was the Australian Law Reform Commission's review a wasted opportunity, you think?
I believe so. In other words, they missed the mark. They missed the point. It seemed to me they didn't really seriously consider overseas experiences, particularly in America, where, for example, in a state like Georgia, when they introduced discrete criminal offences such as isolating an elder, exploiting an elder, depriving an elder of their liberty, that sort of thing, there was almost a six-fold increase in prosecutions as a result of those discrete offences. Now, there are some statistics. We don't seem to have any statistics like that in Australia because we don't seem to keep statistics about the number of prosecutions in relation to elder abuse that may occur here. Mm. So we can't get past the first convincing base of working out what is going on.
And you think this is a first order priority?
I do. We need to disincentivise the perpetrators because they have this sense that they're untouchable, they're immune, they're inoculated by the ineptness of the law in particular and by this family culture we have of, I call it the mafioso syndrome, which is whatever happens in the family stays in the family. And I even go so far as to say that there is a tension, obviously, between a person's privacy, that is, the older person's wish to remain private and not to lay a complaint, and society's view of protecting that older person. This cleavage between privacy and protection. In this area of financial elder abuse, I believe privacy has to give way to protection. And the reality is, despite an older person's desire not to prosecute their son or daughter, they should be, where the evidence is there, of course.
Finally, in your role with the Elder Law Services, you say there's no statistics on this. What's the prevalence of this type of abuse?
I have no idea. I have no idea.
Do you see a lot
of it?
What
I do know is that in my practice, I see a lot of it.
Yeah.
What I also see is a total inability of adult children, the main perpetrators, to really understand that what they're doing is wrong. They don't,
because they feel they're entitled to.
There's that sense as well, but also they can justify it by saying this is what mum or dad would have wanted, or did want, or said to me I could do. So somehow they justify it in their own mind. I've got a classic example of 3 adult children who came to see me about 2 years ago. Their mother was in a nursing home, incapable. They decided that the home that she lived in, which was still sitting idle, was really wasted. So they would sell it using their enduring powers of attorney. They sold it for $820,000. They then split the proceeds between themselves equally. So mum's still in the nursing home, they sell her major asset and split the proceeds while she's still alive. Now, what was remarkable about these 3 people is that when they came to see me as a result of a complaint being laid with the public trustee, it took me some time to convince them what they did was wrong. because it wasn't their asset, it wasn't their money, it was their mum's money. And what was even worse in this case was by doing what they did, they then offended what's called the gifting rules under the Social Security Act.
She lost the pension.
She lost the pension while she's still in a nursing home because of what the kids did. Still couldn't see what they'd done was wrong. There's this incomprehension that family is no excuse for criminal conduct. It's not, especially when mum or dad is still alive.
I must ask, how did you end up in this particular area of the law?
Goes back to what I call the bowel book.
The bowel book?
The bowel book.
Were you having a colonoscopy?
No. About 20 years ago, I was rung by a director of nursing at a nursing home in Brisbane, out of the blue. She asked me to come and see her about a dispute between the nursing home, an elderly resident, and her 6 adult daughters. Some of the daughters were accusing the nursing home of starving their mother to death. So she asked me to come and see her, the Don, and I went to see her, and we sat down in her room, and she said, I can prove we're not starving her to death. I said, how can you do that? And she pushed this book across the table, and she said, have a look at that. That's our bowel book. I said, what's a bowel book? She said, that's our record of every resident's bowel motions every day of their time in this facility. Not only that, she said, we have what's called a stool tool. What's a stool tool? It's a little laminated plastic card that everyone in the nursing home has, showing different pictures of different types of stools, because stools can tell you a lot about your health, and they come in all shapes and sizes, and colours for that matter. So these 2 things they kept a record of for this resident, proving that there was no starvation going on. Now, that experience opened a mind for me in terms of nursing homes. They exist. I had no idea about them really, no experience. And I started to delve into it and realised there was a whole world out there that most people my age had never ever experienced. And it was a developing, evolving, really interesting world as well in terms of older people and their lifestyles in later life. So I got interested, and that's where I started to devote my time to elder law.
Wish we could keep talking, but we're out of time. Thank you so much.
Pleasure.